Good day, everyone. Welcome to our discussion on Title 17 Miscellaneous Provisions of the Revised Corporation Code. In today's video, we will explore the final provisions of the code, which, though often overlooked, it plays a crucial role in the regulations of corporations in the Philippines. So without further ado, let's start the discussion.
Okay, so outstanding capital stocks are shares that has already been issued by the corporation to people like stockholders or subscribers who agreed to buy them. These shares are active and can be used for voting and to get dividends. Even if the subscriber hasn't fully paid for the shares yet, as long as there's a binding agreement for those shares, it is still considered as outstanding. But shares that the corporation has bought back, or are so-called treasury shares, don't count as outstanding because the company owes them again. So they're kind of inactive. For example, if a company issues 1,000 shares, 800 of them are sold and fully paid, 100 of them are sold but not fully paid, but there's an agreement, 100 of those shares were bought back by the company. The outstanding capital stock of the company is 900 shares because 100 of those shares are treasury shares and it is not included. This is important because it tells us how many shares are active for things like voting or for dividing profits.
Moving on to Section 174 of the Revised Corporation Code of the Philippines, which is the designation of the governing boards. Section 174 is the provisions of specific provisions of this code. To the contrary, notwithstanding, non-stock or special corporations may, through their articles of incorporations or their bylaws, designate their governing boards by any name other than as Board of Trustees. In essence, Section 174 allows non-stock or special corporations to designate their governing boards under a name other than the Board of Trustees, as specified in their articles of incorporations or bylaws. But take note that this authority given by Section 174 covers only the non-stock corporations and special corporations. Now, let's move on to the next section, which is Section 175. This section is the collection and use of registration, incorporation, and other fees. The Commission is hereby authorized to collect, retain, and use fees, fines, and other charges under this code, and its rules and regulations. All the documents that the corporations filed in the SEC have their fees, such as articles, amendments of articles and bylaws, increases or decreases in capital stock, and etc. The amount collected by the SEC shall be deposited and maintained in a separate account, which shall form a fund for its modernization and to augment its operational expenses, such as but not limited to capital outlay, an increase in compensation and benefits comparable with prevailing rates in the private sector, a reasonable employee allowance, employee healthcare services, and other insurance, employee career advancement and professionalization, legal assistance, seminars, and other professional fees. It means that all of the fees that were collected by the SEC will be purely for regulatory purposes in the exercise of police power, a sufficient amount to cover direct regulation. Remember that those fees are for regulatory purposes only and not for tax purposes. Take note also that when it comes to the revisions of the fees based on the Revised Corporation Code of the Philippines, if the fees are collected under the rules and regulations promulgated by the SEC can change them at its discretion. However, if the fees are imposed by law, the SEC cannot amend the fees at its discretion. But the SEC is authorized to recommend to the President the revisions, and then the President will revise or amend the fees. Moving on to Section 176 of the Revised Corporation Code of the Philippines, which is the stock ownership in corporations. Under the duties specified by Article 14 of the Constitution, the National Economic and Development Authority, or NETA, shall from time to time determine if the corporate vehicle has been used by any corporation, business, or industry to frustrate the provisions of this code or applicable laws and shall submit to Congress. Whenever deemed necessary, a report of its findings, including recommendations for their preventions or correction. In addition, Congress may set maximum limits for stock ownership of individuals or group of individuals related to each other by consanguinity, affinity, or close business interest in corporations declared to be vested with public interest under the provisions of this section, or whenever necessary to prevent anti-competitive practices as provided in the Republic Act No. 10667, otherwise known as the Philippine Competition Act, or to implement national economic policies designed to promote general welfare and economic development as declared in laws, rules, and regulations. Lastly, when it comes to the recommendations to the Congress on which corporations, businesses, and industries will be declared as vested with public interest, and in formulating proposals for limitation on stock ownership, the NEDA should consider the type and nature of the industry, size of the enterprise, economies of scale, geographic location, extent of Filipino ownership, labor intensity of the activity, export potential, as well as other factors that are germane to the realization and promotions of business. To sum up, Section 176 emphasizes the importance of adhering to nationality restrictions in stock ownership, particularly for corporations operating in industries with constitutional or statutory limits. It ensures Filipino control in critical sectors while empowering regulatory agencies to monitor and enforce compliance effectively.
Okay, so Section 177 talks about the reports that the corporations have to submit to the Securities and Exchange Commissions, or SEC, every year. These requirements apply to both local and foreign corporations doing business in the Philippines. So here's what they need to submit. First is annual financial statements. So these are like detailed report of the company's finances. If the corporation's assets or liabilities are 600,000 pesos or more, the financial statements must be audited by an independent CPA. However, if their assets or liabilities are less than 600,000 pesos, the corporation's treasurer or CFO or chief financial officer can just certify the financial statements on their own. The second one is General Information Sheet or GIS. This is a form that contains details about the corporation like its address, officers, and stockholders. For corporations vested with public interest, these are corporations that deal with public or handle sensitive resources like banks or publicly listed companies. In addition to what was mentioned earlier, they also need to submit first, a compensation report showing how much directors or trustees are paid. Second, a performance report showing how well directors or trustees did their job, plus the criteria used to evaluate them. Now let's talk about the deadlines and penalties. These reports must be submitted every year within the timeline set by the SEC. But if a corporation fails to submit these reports 3 times within 5 years, either in a row or not, the SEC can declare them as delinquent. This means that the corporation could lose its good standing and face legal or operational consequences. The SEC will notify and coordinate with any special regulators like the Bangko Sentral ng Pilipinas for banks before tagging a company as delinquent. Now let's talk about redacting confidential information. If the corporation has sensitive information in its reports, it can hide or redact that part. But they must submit a separate confidential report explaining why that information should stay private. Basically, these requirements are there to make sure that corporations are transparent and accountable about their operations. If they don't comply, they could face penalties.
In Section 178, visitorial power or right of visitation. Power of the state through the proper governmental agency to examine the business affairs, administration, and condition of corporations. Not only SEC have visitorial power, Other governmental agencies also have visitorial power like SEC, PIR, Insurance Commission, DOLE, and COA. Visitorial power in general. In nature, it is a public right as distinguished from the right of inspection of the corporate books and record by a stockholders in Section 70, which is merely a private right existing in virtue of his stock ownership. In purpose, the purpose of visitation is to supervise and control the management of corporations and keep them within the limit of their legitimate powers. In scope, it extends to any corporations transacting business in the Philippines, even therefore the corporations created by special laws and foreign corporations in that exercise of its right of visitation for purpose of taxation and regulations, or to facilitate the accomplishment of any other proper end. The state has the power to compel corporation to render reports. Example for this section is tax audit by BIR. The Bureau of Internal Revenue or BIR uses visitorial power to examine financial records and other documents to ensure taxpayers comply with tax law.
Section 179 of the Revised Corporation Code states the powers, function, jurisdictions of the Commission. So those powers are to exercise supervision and jurisdiction over all corporations and those people acting on their behalf. The SEC can also retain jurisdiction over pending cases involving intracorporate disputes. They can impose sanctions for the violation of this code. They promote corporate governance and the protection of the minority investors. They can also issue opinions to clarify application of laws, rules, and regulations. So they can also issue a cease and desist order to prevent imminent fraud or injury to the public. So which means that they can stop a specific activity that is illegal or harmful to the public interest. So examples of these activities may be the sale of unregistered securities, fraudulent investment scams, or other illegal activities that could harm investors. So they can also hold corporations in direct or indirect contempt. So they can issue a subpoena duces tecum, which is a legal order that compels a person to produce specific document or requirements that is relevant to an investigation. So the commission can also summon witnesses to appear in court proceedings. So the SEC can order examination, search, and seizures of documents, papers, files, and the book of account of any entity or person under investigation. So this power allows the SEC to gather evidence or information for investigating violations of laws and regulation. So if they enforce such power, they can uncover fraudulent activities, false information, and also gather evidences. So they can also suspend and revoke the certificate of incorporation of a corporation. They can dissolve or impose sanctions of corporations upon final court order. So they can also issue a writ of execution and attachment to enforce payment of fees, fines, and other dues. So a writ of execution is a court order that enforces officers to seize and sell the property of a debtor. So if an individual or entity fails to pay a fine imposed by the SEC, the Commission can obtain a writ of execution to seize and sell the debtor's asset, while a writ of attachment is a court order that allows a creditor to seize the property of a debtor. So, the Commission can also prescribe the number of independent directors and the minimum criteria in determining the independence of the director. So, publicly listed companies, they have a certain number of independent directors on their boards, which can vary depending on the size and the nature of the company. So they can also impose or recommend new modes by which the stockholders, members, directors, or trustee may attend. So these modes may be virtual or remote meetings, votings through proxy, as well as hybrid meetings.
So these new modes of application or participation can increase participation and improve efficiency. So the Commission can also formulate and enforce standards, guidelines, and policies, rules, and regulations to carry out the provision of the RCC. And finally, they can exercise such power provided by law or those that may be necessary or incidental to carrying out the powers granted to the Commission. However, in imposing these penalties or supervision requirements, the Commission shall take into consideration the size, the nature, and the capacity of the corporation. And also take note that no court below the Court of Appeals shall have jurisdiction to issue a restraining order, preliminary injunction, or preliminary mandatory injunction in any case, dispute, or controversy that directly or indirectly interferes with the exercise of the powers and responsibilities of the Commission. So, for example, if the SEC is investigating a potential securities fraud case, a lower court cannot issue an injunction to stop the investigation or prevent the SEC from taking necessary actions.
Section 180, Development and Implementation of Electronic Filing and Monitoring System. The Commission shall develop and implement an electronic filing and monitoring system. The Commission shall promulgate rules to facilitate and expedite, among others, corporate, name, reservation, and registration, incorporation, submission of report, notices, and documents required under this code, and sharing of pertinent information with other government agencies. Section 180 applies to the Commission's establishment and use of an electronic filing and monitoring system. This effort aims to streamline a variety of corporate operations including name, reservation, registration, incorporation, and filing of needed reports and papers. The Commission's goal in deploying this system is to improve efficiency, minimize processing times, and improve information accessibility. Furthermore, it will make it easier to share relevant data with other government agencies, resulting in a more integrated and responsive regulatory framework. For example, a company wanting to incorporate may have previously required to present tangible paperwork in person or by mail to reserve a corporate name and complete the registration process. With the electronic system in place, the company can complete these duties online while obtaining confirmations and updates electronically, which speed up the process and eliminate administrative hassles. This upgraded technique enables real-time surveillance and more efficient communication between the business sector and regulatory organization.
So the next section is Section 181. It states that a corporation may provide an arbitration agreement under Articles of Incorporation or bylaws. So instead of going to the court, the corporation may settle their intracorporate dispute through arbitration. Note that their dispute must only be intracorporate. It cannot involve a criminal offense or third parties. So this arbitration agreement is binding on the corporation, its directors or trustees, its members or shareholders, its executives and officers. So even if they go to the regional trial court, their case shall be dismissed and the arbitration agreement is to be followed or respected. So in order to be enforceable, the arbitration agreement shall indicate the number of arbitrators and their procedure for their appointment. So the arbitrators are appointed by a designated independent third party or by the failure of such by the Commission. And this arbitral tribunal or group of arbitrators now have the power to decide if they have the jurisdiction, if the arbitration agreement is valid, and take temporary actions to protect the parties' rights, to prevent unfairness, and to ensure that their final award or final decision is followed. And this final award or decision is legally binding after 15 days of the parties' receipt of such decision. and it may only be temporarily stopped by the parties by providing a bond or getting an appellate court order.
Section 182, Jurisdiction over Party List Organization. The powers, authorities, and responsibility of the Commission involving party list organization are transferred to the Commission on the Election or COMELEC. Within 6 months after the effectivity of this act, the monitoring, supervision, and regulation of such corporation shall be deemed automatically transferred to the COMELEC. For this purpose, the COMELEC, in coordination with the Commission, shall promulgate the corresponding implementing rules for the transfer of jurisdiction over the above-mentioned corporation. Section 182 is described how the Commission on Election COMELEC will take over the control over party list organization. This means that the COMELEC will now administer all powers, authorities, and obligations previously held by another institutions. In connection with party list organizations, the shift of monetary supervision and regulation responsibility will take place automatically 6 months after the law goes into force. To assist this transfer, the COMELEC, in collaboration with the Forward Commission in charge, shall create and implement the required rules and procedures. For example, imagine the Department of Social Affairs was previously in charge of party dispute groups. In that situation, following the passage of this legislation, responsibility would shift to COMELEC, which would then oversee the registration, monitoring, and regulation of this organization. During the 6 months transition phase, the COMELEC and the prior commission would collaborate to achieve a seamless transfer of duties and responsibilities.
The next section is Section 183, which states that this act shall not change the existing laws for special corporations like banks, insurance companies, and non-bank financial institutions. So these special corporations shall continue to be regulated by their special laws and agencies like the Bangko Sentral ng Pilipinas and Insurance Commission. Next is the Section 184, which states that even if a corporation is dissolved or the law itself changed, it won't affect any existing rights, remedies, or liabilities of the corporation, its directors or trustees, its shareholders or members, and officers.
Okay, so Section 185 is about how the new rules in the revised corporation code apply to corporations that has already existed before the code became law. So it basically says that if a corporation is affected by the new requirements, they have up to 2 years from the time that the law took effect to comply. So for example, if the revised corporation code requires something new like submitting a general information sheet or a transitioning to a one-person corporation or OPC, existing corporations have a maximum of 2 years to make those changes or adjustments. So it's like giving them a grace period to ensure that they have enough time to comply with the new rules without immediately penalizing them. Section 186 is the separability clause, which is like a backup plan for the law. It means that if any part of the revised corporation code is declared invalid or unconstitutional by a court, only that specific part will be affected. The rest of the law will still remain valid and enforceable. For example, let's say one of those sections of the law is found to violate the Constitution. That section would be stopped being applied, but the other section of the code would still work as normal. It's basically there to ensure that the whole law doesn't fall apart just because one part of it has an issue.
Section 187 of the Revised Corporation Code is the repeating clause. So it states that any law, decree, executive order, rule, or regulation that contradicts or is inconsistent with any provision of the Revised Corporation Code is repealed or modified accordingly. So for example, if the old law requires a minimum of 5 incorporators to form a corporation, but the revised corporation code allows a one-person corporation, then Section 187 would render the previous requirement null and void. Finally, the last section of the revised corporation code is Section 188. Section 188 deals with the effectivity of the law. It states that the revised corporation code takes effect upon its publication in the official gazette or at least 2 newspapers of general circulation in the Philippines. So for example, the revised corporation code was passed into law on February 20, 2019 and became effective after it was publicized in 2 newspapers on February 23, 2019, which means any corporate transaction or any corporate action occurring after February 23, 2019, it would be governed by the provisions of the revised corporation code.
So that is all for the discussion of Title 17 Miscellaneous Provisions of the Revised Corporation Code. We hope that you learned a thing or two in this video. Thank you!